welcome everyone to the Wall Street Blockchain Alliance's Crypto Roundup for the week ending November 3rd, 2023. My name is Quaranta, chair of the Wall Street Blockchain Alliance. I am here with my co-hosts, the mother of blockchains herself, Joshua Ashley Klayman, and our very special guest, the one and only Anne-Marie Tierney. Before we begin, everyone, just a couple of quick disclaimers that Josh is way used to at this point. Please keep in mind that nothing discussed is accounting, investment, legal, or tax advice, and obviously everything we discuss here is our own personal opinions and don't necessarily represent the opinions of our firms. Josh, Anne-Marie, good morning.
Good morning.
Anne-Marie, this is your first time on our show, and it's so great to have you. Josh and I often work up an agenda, and I just throw the agenda out. The news of the past 24 hours, for everyone or anyone who hasn't heard, Sam Bankman-Fried convicted on all counts. I think it was money laundering, wire fraud, securities fraud, among others. Josh, what was your first thought when you saw your phone blow up?
So, people talk about divine justice. This was somewhat of sublime justice. The fact that the conviction happened so fast and that it happened on the 1-year anniversary of CoinDesk's award-winning reporting, exposing Alameda's balance sheet and basically showing that the whole empire was, some might say, a house of cards. To the day, it's really shocking that it was decided so fast, at least to me.
Agreed. Anne-Marie, what were your thoughts? And we, the three of us, have had these kind of conversations in our legal working group and in events that we've gone to. Were you surprised by the rapidity of the judgment?
Yeah, I echo Josh's. I think the jury was out for like a few hours, and to come out with a decision sort of very late in the day yesterday, right? My phone started blowing up. I felt like it was around dinner time. So I felt like it was pretty quick. I know that we have some friends and colleagues who were actually going to go down to the courthouse at some points during all the, the testimony, and I never got a chance to do that. But I thought the whole thing was completely fascinating. And when he decided to take the stand, I think that probably hastened the decision-making of the jury from everything I'm reading. But yeah, I didn't realize it's a 1-year anniversary, Josh. That's fascinating. All
wrapped up with a bow in 1 year.
Yeah,
for the record, Anne-Marie, Josh has been our resident attendee at the courthouse at one point. Josh, one day, but I'll just keep going back to that well. I'll go back to that well over and over. I want to raise a couple of things that I thought were interesting, and you both know I'm not an attorney, but I have a lot of attorney friends. One of the things that often came up in the conversations about the trial was just kind of how poorly his defense seemed to be built. And again, no judgment on any attorney, particularly or any particular law firm. Was this a very hard defense to mount, and was a mistake made putting him up on the stand? Anne-Marie, what were your thoughts?
Well, I thought it was very interesting that what did the judge cited him for, repeatedly not being able to recall, right? And I think that the prosecution would ask him something. He's like, I don't remember saying that, or I don't remember doing that. And then they would pull up very specific emails, very specific texts, very specific, tweets. So I feel like I think I read that one of his defenses was that there was an overwhelming amount of paperwork and they didn't have a chance to go through all of it, but they had months and months and months and months and months to prepare. And, his tweet, what was the date of the tweet, Josh, that he said everything's fine? It was like November 7th or whatever the tweet was. It said everything's fine here. And then the next day it all blew up. He doesn't remember tweeting that. I just don't, it just didn't, it felt like he was prevaricating a lot just based on what I've been reading. But I think his decision to take the stand, I don't know that his lawyers probably supported that decision, not being part of the inner circle of his defense. But I think that was probably a continuation of his need to get out in front and tell his story and be his own voice. And we saw that after he was arrested, when he was continuously talking to the media, continuously posting things, continually tweeting things. And people are like, are your lawyers okay with this? He's like, no, but I want to get the record clear. So I think there's that, in my estimation, that hubris that, he probably doesn't believe that everything he did was wrong, which is kind of sad. But just I wish I'd been in the courtroom for some of his testimony. I think it would have been fascinating to watch him.
It's
when they crossed him.
It's interesting, Anne-Marie. Thanks for that. Some of the things that we've read in the news, and I've never met him. I don't think the three of us have ever met him. But when you look at how they have portrayed him, it almost, I remember one columnist had written, it's almost like he thinks the proceeding is beneath him. And when I read that, my head just exploded. Like, you're on trial essentially for a good chunk of your adult life, right? How could this be beneath you?
Right?
Yeah. And Josh, did you, what was your perspectives? And I have joke about, you were there, you attended, and I get that in the audience, but what were your thoughts about that kind of demeanor? I know you're not a litigator, but wow, how does someone respond to a trial like that?
I mean, it's a great question. Let's all hope we're never in a position like that, or we never do anything that would require us to be in a position like that.
I will not be.
I mean, yeah, exactly. But I do wonder. I mean, I can't imagine, just as a person. Okay, I'm obviously, as you noted, not a litigator. I can't imagine that would be a conscious sort of thing that you're trying to project, right? I think, to me, it goes more along with what Anne-Marie was saying about hubris potentially, or I mean, to perhaps take a I don't know if it's deservingly, but a more generous view, just a lack of a disconnect between
the reality, a lack of connection with the reality.
Yes, and so I mean, also I don't know if that could be a defense mechanism, something like that, where you're just like divorced from reality.
Yeah.
Right. And that's your protective thing, is like, oh, this can't really be happening. I mean, I believe he was facing, or is facing, 115 years. Right. Yeah. And so I think a big question is going to be whether that would be consecutively served, or how that will be served. And certainly there are others who might have predictions about that. But I think I read that the sentencing isn't for several months.
I believe March of next year, Josh. And thanks for that. Before we move on, for everyone in the audience, LinkedIn Live and Twitter X, I keep doing that. Thank you all for joining us. If you have comments or questions for Josh or Anne-Marie, please put them in the chat. We're happy to address them. Josh, I'd love to stick with you for one moment. One of the things that really struck me early on in the trial, and the judge was pretty strident about this, was this idea of advice of counsel defense. And I wonder, and I'd love you both to weigh in on this, would that have been able to save him? Or what was the judge's logic around saying, you can't bring this up as part of the defense? I'm curious about the mechanics of how that's decided. Do either of you want to start with that?
So, I'll let Josh.
Thanks, Anne-Marie. So in terms of the mechanics of how it's decided, I don't know what was going exactly through the judge's mind, but I did note, like, I believe it was last Wednesday, when the lawyers for Sam Bankman-Fried submitted a pretty detailed letter, right, going through the various points that they wanted to cover, which covered everything from, the data retention policies, which could have an impact on the disappearing signal messages and things like that the prosecution made a big point of, but also everything from, the loan documents that were entered into, I believe the payment agent agreement, or whatever sort of agreement there was between Alameda and FTX, the setting up of the relevant bank account at Alameda, and so on. And so as many listeners and viewers know, there was the somewhat unusual, I believe, at least it was something that the judge said he hadn't done for a very long time, measure taken of last Thursday, having Sam Bankman-Fried sort of preview his testimony, and coming out of that, as we know, the judge really only let the defense present about the data retention matters, which I thought was really interesting. And I had asked in, some friends who may not be criminal defense lawyers, so that caveat applies, but whether something like that could form the basis for an appeal, right? The fact that the exclusion of those types of defenses, together with the judge's exclusion in the past of many experts that Sam Bankman-Fried's defense wanted to present, whether this could be something that could form the basis of an appeal. And my understanding from them is that potentially it could, although that's really the extent to which I can say. My sense is that at least at some level, the judge didn't want the jury to be going on sort of like that it would be distracting to the jury to go into questions about this legal advice. But I do, one does wonder what that case might have looked like and what change could have occurred.
Josh, thanks. Anne Marie, on that question and some of the items that Josh just brought up, what was the logic behind prohibiting some of the experts that Sam Bankman-Fried's team wanted to have testify? Any thoughts about that?
I mean, I'm not a litigator, so anything that I say is just guesswork. Would they normally exclude experts if they weren't pertinent to the case or pertinent to the actions that are being considered? I don't know, and I'm not close enough as Josh is to know like exactly what experts they wouldn't allow. But I know that the judge expressed some frustration with the circularity of his conversation and his testimony. I did think it was super fascinating that they let him do kind of a trial testimony. Again, I'm not a litigator. I've never seen that before, Josh. I don't know if that's common or not common, that kind of somebody kind of does like a preview in front of the judge in closed chambers and then has another opportunity to testify. And if it went badly in the kind of like the closed court, I'm surprised that his lawyers let him do the public testimony. But I don't know. So I don't know who was excluded or why, or whether the judge just thought there's enough facts here that you need to work through, that we don't need to pull in other issues that are not pertinent to the case. But I just don't know.
Yeah, and thank you, Anne Marie, and based on what the three of us have just raised, and I think, Josh, you believe it will happen, but Anne Marie, Josh, you do think he'll appeal? Would it make sense for him to? And the reason I bring that up in context is I think what doesn't get reported a lot is there are another series of charges that he's going to trial for prior to his sentencing in March. So I wonder, is there a point in appealing or not? As a non-litigator, I don't know.
Well, my other question is, I mean, he was operating in the Bahamas and arrested in the Bahamas. So isn't he also potentially facing criminal charges in the Bahamas? So I don't know. I mean, the bad action and the fraud all occurred for the most part offshore. And I was reading, in the Wall Street Journal or someplace this morning, they said it was like the biggest fraud in U.S. history. But I'm thinking this is like a global fraud, right? This is not a U.S. matter. They were in the Bahamas, working in a highly regulated jurisdiction, and obviously, not following the rules of the Bahamas. And the Bahamas allowed him to be extradited to the U.S. But I don't know, is there still action against him pending in the Bahamas? So
if I recall correctly, I think Bahamas.
I don't remember what happened there, but it's interesting to me they're calling this U.S. fraud when I think of it as a global fraud.
Yeah.
And so he has more coming out. I feel like if we go back to the kind of maybe like either hubris or potentially lack of connection with reality, there's no downside for him to appeal, right? He wants to be heard. He doesn't think he did anything wrong. Why wouldn't he appeal?
Right. Go ahead, Josh.
I mean, that's what I would think. I would imagine that it's use it or lose it, right? And if you appeal, there's always the chance. I have to wonder, if you're facing 115 years in a federal case, and as I understand from litigation colleagues, or not colleagues rather, but litigation friends, that actually, unlike other types of sentencing, where you may be sentenced to a year and you serve 4 months or something like that. That's not the case with federal charges and federal prison. And so I would imagine that he would want to exhaust all appeals, just because otherwise, not legal advice, obviously none of this is, but just as a person, thinking about the rest of your life, you're 30 years old, and just how do you keep hope? I would imagine he would want all of the appeals he could.
Yeah.
One last wrap up on that. And again, the jury has spoken. A colleague and friend, Josh, had mentioned to me, well, it's a white collar crime. He's got no criminal history. He won't do anywhere remotely near 115 years or whatever it may be. I'm not necessarily sure that's true in the context of the scope of this particular fraud. And again, knowing that no one here is a litigator particularly, do you think the sentencing guidelines take into account those things, or will it be, hey, you perpetrated such a large fraud, this multi-decade sentence is justified?
I'd be curious to know how long people served who were, convicted around other massive frauds like Enron or, some of these other massive billion-dollar frauds that were actually perpetuated, took place in the United States, right? So again, like, I don't know what the sentencing guidelines are for this level of bad actions, but I can't imagine that these other major financial fraud convicted people served multiple decades. Like, it just doesn't feel like that's been the case, but I don't know. I would assume he's going to get convicted, get sentenced for a long time, but good behavior, all the kind of things that get people out faster. I don't know.
Yeah. No. Go ahead, Josh.
He's going to be in jail for 100 years, or even 50, but I don't know.
Yeah, it's hard to say. I mean, certainly I'm not aware of the sentencing guidelines either, but I would say my understanding is that part of the things that may come into play in the judge's mind is, do we think this person's rehabilitatable, right? He's young. Yeah. He's relatively young, and while you might give a 100-year sentence to Bernie Madoff, right, to whom he's often compared, I forget exactly how long that sentence was, but it was long, right? That was already, he was already at least double the age.
Yes.
He was
in the 70s, right?
Yeah. And so thinking about that, I would have to imagine that at some level, something like that may come into play. I don't know that Sam Bankman-Fried in his testimony did himself any favors in that regard, right? In showing that he was in fact rehabilitatable, or that he had in fact remorse. Although I'm just reading from the same papers and podcasts and listening to the same thing as everyone else is. So it's all going through a filter.
Thank you both. I kind of want to abstract away from just the SBF trial, because there's so much. I know there's so much we can talk about there, but I think it's important, Anne-Marie, and it's a good point. When we look at the SBF trial, it really distracts from a lot of the work that's happening in the crypto markets. And we all have friends that are not pro crypto. We have friends that are not pro blockchain, and certainly some regulators are not pro crypto at all. Are you concerned that this conviction feeds into what I'll call a narrative that is, oh, look, it's all fraudulent, it's all for illicit activity? We've got Congress people, candidly quoting now known incorrect facts about using crypto for terrorist financing, which is a terrible thing. Any cent of it is a terrible thing. But are you concerned that this just paints that still uglier picture about crypto going forward, and that holds the marketplace back? Anne-Marie, what are your thoughts?
I think it's had a significant impact. I mean, part of the criminal activity here was utilizing investor funds to, provide political donations to both parties, right? Kind of illegally through PACs. So where you had a significant amount of support, I think, amongst, at least particularly in the Republican side of the Senate and the Congress, right? And then the Democrats as well were getting more comfortable with it. Once this happened, they all kind of ran for the hills. And so all this legislation that had kind of wide bipartisan support, if it was crypto related, I think a lot of people took a step back and said, I can't be seen to be supportive of this industry right now. Yep. So I think that definitely had an impact on the Hill. I think it gave the SEC more ammunition to go after a wide variety of digital asset participants in the U.S. And charge them with bad actions, even if we think in many cases the companies who are being charged will prevail, hopefully at least in significant ways. So I think it's definitely given the SEC more ammunition. It's made Congress back off legislation that would provide the clarity that we need, and it's really made people be hesitant to, I think, associate themselves with the crypto industry if they think they could get the blowback from the other side. And with respect to, the use of crypto or digital assets to fund illicit activities, I think the Wall Street Journal just printed a retraction, am I correct, about their original reporting that it was millions and millions of dollars were funding Hamas through digital assets, and it ended up being maybe like $500,000. So I think they've had to print a retraction there, but that once that message gets out, it's hard to pull it back, right?
Yeah.
And we've got Senators Warren and others on the Hill saying we need to shut this down now. It's being used to fund terrorist activity when there's no facts to support that argument at the level that they're making it. So that's harmful as well. But it's
Anne-Marie,
I'm sorry, Ron, go ahead.
No, I was just going to say thank you for that, and I think the Journal issued a correction. They didn't issue a full retraction.
Correction.
But, right, yeah. But Josh, to that point, do you agree? And I think one of the other questions I would add to that, and you and I've we've all been in this crypto space for some time in our relative professional verticals. Is the industry doing enough to say, look, Sam Bankman-Fried had nothing to do with crypto per se. It was fraud. It could have been fraud of freight contracts, of
Correct.
stocks, whatever it may be. Are we doing enough, Josh?
I mean, I think one can never do enough, right? But I do think having a strong reaction supporting the conviction if people, believe that that's the, I wasn't there for all the testimony, so relying upon the jury, right? But really making the voice heard that no, we stand apart from this. This was fraud, right? And I think it was a post that I saw on X, the artist formerly known as Twitter. I think it may have been by Eric Voorhees, although I don't have it in front of me right now. But I recall reading it last night, and it said something like, just remember, this was exposed by the industry. This is a paraphrase, obviously, by whoever it was. It may not have been Eric, but I think it was. And saying, like, this was not the regulators who had discovered it. It was actually industry. It was actually CoinDesk and the reporting, and then we saw everything unfold on Twitter, right, in real time. And so I think that's a really important thing, is to say, actually, no, the crypto space doesn't want to support these kinds of characters and these sorts of schemes. Actually, it was the industry itself that exposed this, pursued it doggedly, and and we're testifying in many cases as witnesses for the prosecution, not just the co-conspirators. I guess I shouldn't say alleged co-conspirators anymore, because there was the conviction, but not just those folks, but other people from industry as well who weighed in and said, we suffered harm. We were fooled. Essentially, we were defrauded, and really wanting to hold accountable bad actors.
Yep. No, Josh, thank you so much. Anne-Marie, Josh, I'm going to rip up the script as Josh is painfully.
Wait, there's still a script?
There's all the time. Like, there's a script. Like, you're always saying you're ripping something up. I'm like, there's no script in our space, but go ahead.
No, I'm just spitballing it here at this point, Anne-Marie. But you did open up the can of worms. You mentioned the SEC, so I want to talk a little bit about that. And again, Josh, I'll share this with you. I might have mentioned this the other day. I have colleagues who are like, you're really tough on the SEC a little bit, Ron. I don't mean to be, but I do want to talk about a couple of things. One is certainly recent court decisions have kind of knocked back the SEC on some of their proposed rulings. The recent GAO rendering on SAP, which is amazing. Anne-Marie, do you want to dive into the import of that and the impact of the GAO saying, look, this was a rule, and you should have treated it like a rule, and you didn't. What does that mean for us?
Well, I think that, if people in the audience don't know what SAB 121 was, it was a staff accounting bulletin that the SEC put out like three years ago now. How long ago?
I think it was two. Actually, I think it was two, yeah.
That basically told publicly registered companies that they had to account for crypto in a way that was very negative for their financial situation. They had to account for them on their balance sheet in a way that they don't have to account for any other asset class. And what that does specifically for publicly registered banks or custodians, it made it virtually impossible for publicly registered banks and custodians, which are many, many of the largest custodians in the traditional asset custodial space, to custody crypto. And so that created a real problem where you started having chokes in the industry where people were trying to find custodial solutions and they couldn't go to traditional banks or other places. But the SEC kept saying, well, we don't think maybe state chartered trusts can be custodians for digital assets, and we're not sure if state chartered banks can be custodians. So they kept choking down who could be a custodian for digital assets. And we saw that in a proposal that the SEC put out around registered investment advisors and their custody obligations. And so it was really, really problematic. And so many, many people in the industry kept, sorry, my dog just, sorry, hi. My dog didn't want to go out with her dog walker.
Dogs are automatically members of the WSBA, Anne-Marie.
So what it basically meant was through this guidance that they put out, which was not a formal rulemaking, it was basically impacting the entire industry in an extraordinarily negative way. And many market participants pushed back. You had, I think, Mr. McHenry, House, he was the chair of the Financial Services Committee. They wrote a letter to the SEC saying you can't just put something of this import out in guidance and then not provide anything else. And basically the SEC took a position that this has always been our view. We're just now writing it down and putting it out, which is actually not supposed to be the way that it works. So for the GAO to react to the letters that came from the Hill and from the SEC itself, I think, Hester Peirce and others pushed back on it as well, to basically come out and say, 100%, this was a violation. This was acting in a way that's not consistent with the Administrative Procedures Act. This was a rule. This should have gone out for public comment. You can't do this way. So I think that basically puts SAB 121 on the shelf. I think I'd be really fascinated, Josh, to see how your law firm or other law firms are going to advise around this. But it feels like I would be surprised if a company would take the position that it doesn't apply because they'd be terrified the SEC would come after them, public registered company, when they're filing their financial statements on an annual basis in their Form 10s or Form 10Ks or wherever that they're filing. But it's a really fascinating thing that the GAO came out and said, you're acting in a bad way. You've got the courts coming out, like in the grayscale decision, that they're acting in an arbitrary, capricious fashion, blocking a spot Bitcoin ETF. You have the Ripple decision. And so it's really becoming external government agencies and the courts are having to put the parameters around the SEC that the industry has thought have been needed for a really long time. That's a very long answer. Sorry.
No, that's perfect, Anne-Marie, and I appreciate that. And Anne-Marie, to build on that a little bit, and Josh would love to pull you into this, those firms that you're referencing are publicly traded companies. Some of them are banks, and many of them had done work to try to accommodate customers.
Correct.
To custody.
Mellon, right? US Bank, Citi, all these, Fidelity, State Street, all of these companies that provide traditional custodial services were trying to find ways to provide custody for digital assets. And once that happened, they also can't do this.
Yep. No, Anne-Marie, perfect. Josh, to build on what Anne-Marie's talking about, would love your opinion there. And one of the interesting perspectives we've seen in the industry and in some voices on the Hill is the SEC doing this essentially forced participants in this marketplace away from trusted providers to the kind of FTXs of the world. Do you kind of agree with that, Josh? What are your perspectives?
So I have to be a little bit careful how I talk about this kind of stuff, just for obvious or perhaps not obvious reasons. But what I would say is, yes, I mean, certainly if you think about banks and the capital requirements that they have, right, the requirements of what SAB 121, if it applied to certain types of arrangements, would be, I'll keep it vague, could be challenging. And if you think about the SEC's proposed safeguarding rule, right, which would seem to mean that banks and others would, like those traditional trusted parties, would be the natural, ones we trust for custody in those regards, although holding aside the statements by OCC, Treasury, all the other stuff coming from the other
FinCEN, yeah.
When read in concert with SAB 121 and taken to its logical end, it really calls into question whether we can rely on those trusted parties, as Anne-Marie said. But I think there's a lot of aspects of SAB 121 just within itself, thinking about the different kinds of arrangements that can and will and do exist, and whether those fall within the definition, first of all, of crypto asset, but then second, whether the types of custody fall within that as well. And so I think, it's not just companies that are feeling this kind of, and institutions that are feeling this kind of question and but also accounting firms, right? And how they are going to advise. Because remember, this was this is a staff accounting bulletin, right?
Yeah.
And I would just say, as I think folks know, who are watching probably, the GAO's determination isn't binding. And the SEC has come out reportedly and said, like, well, I'm paraphrasing, but this doesn't change anything for us. But it could be. I mean, Congress could take things forward. Lawsuits could take things forward. Again,
Right.
because of the GAO's determination that this was actually a rule and not just a clarification, as it had been styled. But my understanding is, informally and not from any not any official way, but it's just that some of the very questions that industry is having about the applicability of and needing clarifications on SAB 121, even before this US GAO determination.
Yep.
That's being echoed in the halls of the SEC as well.
Yeah.
And
Josh, Anne-Marie, good point. We've only got a few minutes left. I want to do a quick shout out to our friend and fellow co-host David Brill, who couldn't join us. I believe he's on the Learjet right now, Josh. We don't have time right now to talk too much about it. He and I often talk about the markets, but for those of you who are watching again, thank you for tuning in. We'll be speaking next week. There's some interesting trends that are happening for on-chain data around crypto assets. I think the three of us have seen crypto asset market prices rise pretty precipitously. Many believe in anticipation of an ETF, which we will definitely come to. But anticipation of next week, please tune in. David and I will analyze some of the on-chain statistics. Potentially there's a correction in the works. This is not investment advice. We don't know, but it's interesting data points to analyze. I want to end with one thing around the ETF stuff. And again, I'm coming back to the SEC simply because they're the regulator du jour right now in a lot of the conversations that we're having. Anne-Marie, do you see a shift in perspective at the regulator around ETFs? And I often do this to Josh all the time. Do you predict an ETF before the end of the year or some type of approval?
Well, I don't see a shift in the regulator. I see a shift in the pressure on the regulator, right? So you have, you have a decision that acted in an arbitrary, capricious manner. They've approved the futures products for, I think, Bitcoin and ETH now. They have turned down, I don't even know the number anymore, 20 different issuers over the course of the last, almost 10 years since the Winklevoss filed their initial Bitcoin ETF application. It's harder and harder for them to justify denying it. Many of the filers have addressed the surveillance issues. They've entered into surveillance agreements. They have, some of them, Bitwise for one, Fidelity the second, provided like significant lead lag analysis showing that these markets are overseen by regulators in the commodity space in a meaningful way. I think most of the market believes that something will be approved. Our friend Greg Exthalis, who loves to read every single word of every single one of these filings, he's predicting January, which is the next time I think the comment period expires for the ones that have been resubmitted. I think I've lost track. I don't remember if it's 8 or 9 or 10 on file right now. Many of these issuers have filed multiple times over the years. So I think the question is, do they approve all of them at one time, which I think is the fair thing to do? Or are they going to kind of do what they did with the futures product and just approve one out of multiple, 3 or 4 that were on file at the time? So I think I'll follow Greg's lead and say yes, maybe January. And then I'm hopeful that they'll approve everybody at the same time.
Greg, shout out to Greg Exathalis, member of the WSBA. We'll all just agree to follow him. We're just about out of time. Josh, what are you working on? What's coming up for you in the next several days?
So aside from catching up on every kind of reading, and I think one thing we didn't even talk about was, for example, Biden's executive order on AI that came out this week. I think there's a lot of stuff to be delving into, certainly to go beyond like the fact sheet and stuff like that into really the implications. So there's a lot of that. I also, next week, I'll be in Portugal for part of the week for conferences and meetings. So that should be, a fun change of pace. But I'll be back in time for next week's.
We will need the Portugal update. We'll need the Portugal update next Friday. Josh, thanks so much. Anne-Marie, what's next for you? What are you and the team at Liquid Advisors doing in the coming week?
So we are busy with clients who are launching different investment fund products in the digital asset space, which is exciting. One of our clients launched this week. And then we are gearing up. Next week is DC FinTech week. So be in DC. Really interesting, right? From last year to this year, Josh, like one thing I'm noting is that a significant amount of time at conferences that was kind of purely crypto maybe for a while. Now there's like a full day of AI at DC FinTech Week, and then a full day of policy. So I'm excited to be in DC and kind of catch up on the AI space and spend some more time thinking about crypto policy.
I'm not doing anything remotely that exciting. I am stuck in a betting pool about who's going to be the actor that plays SBF in the coming screenplay.
Who are you taking?
Jonah Hill.
Oh, good one.
Ooh.
Yeah.
It might work. I'm not quite sure. Josh, Anne-Marie, you are both the best. We're just about out of time. Anne-Marie, great to see you. You have to come back. Josh, as always, a privilege. We will see you all again next week. Thank you so much, everyone.
Bye, guys.
Bye-bye.
You take care.